The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
I'm Vinnie Politan. The subject of my investigation is the death of Boston police officer John O'Keefe. His girlfriend Karen Reed has been accused of the murder, but says she was framed by the police, who are the ones who actually killed him. Here's the story. It was the most divisive trial of 2024, a case that caused confrontations inside the courtroom, outside the courthouse, and all over social media. Karen Reed is accused of running over her Boston police officer boyfriend, John O'Keefe, on purpose. Prosecutors charged her with murder. Then, a local video blogger and social media influencer covering the story transformed this case into something else. He is known as Turtle Boy, and he has tens of thousands of followers who all believe, based upon the evidence that they've seen, that Karen Reed is innocent and she was being framed by police. They mobilized and created the Free Karen Reed movement, and this trial turned it into a polarizing issue, much like the left versus the right in politics. That divide seeped into the jury room as the first trial ended with a deadlocked jury. Now, the battle lines have been drawn, and both sides are preparing for this epic retrial of the century. And that's not an exaggeration. There's never been a retrial quite like this, with this much anticipation and buildup. And all the battles that were fought the first time around, there are new battles that are being fought in the buildup to this case. And this coverage of this trial, to me, is so much different because of what is happening outside of the courthouse. And we've covered trials where there are protests and people are saying this or that. This is different. This is different. You have people who had no connection to Karen Reed, people who didn't know Karen Reed, didn't know John O'Keefe, but learned about the story and got invested in what was happening. And they are what I call true believers, people who absolutely believe Karen Reed is 1,000% innocent and that there's something wrong with our system. And they've made themselves known, so much so that the judge had to create special rules to keep them away from the courthouse during the first trial. Take a look. Free Karen Reed! Free Karen Reed! Free Karen Reed!
Karen Reed was framed, and the world knows it. We have been subjected to domestic terrorism. We will not be terrorized anymore. Free Karen Reed! Let me free Karen Reed!
She's been framed.
She has to be exonerated. This is insane. I'm excited to see her have her day.
That was the first case. And I mean, they showed up pre-trial hearings, pre-trial motions. They were there. Then during the trial, they're there day in and day out. They're there when Karen Reed arrives in the morning. They are there when Karen Reed leaves at the end of the day. But they can't get into the courthouse because they're in this little tiny courtroom for this huge case. But I'm wondering, as we get ready now for the retrial of the century, I've got a question. It's our first question of our investigation. Does Karen Reed have more support now? Right? The first time this trial went, people knew about the trial. Locally, obviously, they knew about it, but nationally, it wasn't quite there. From my perspective, the case and the story has become bigger since the first trial. So let's try to answer this question. Joining me, Karen Read supporter and creator of the Justice for Officer John O'Keefe and Karen Read Facebook page, Nick Rocco is with us. And joining us on the phone right now, author of the book, Storm of Suspicion, the Karen Read Trial, Kevin Lenahan is with us as well. Some dramatic intro there for Nick. All right, Nick, let me ask you, from your group, right, from your Facebook group, are there more people joining now? Is the temperature of their passion higher now than it was at the first trial? Is it the same? Is it less? What are you sensing?
I think more and more people are outraged. You know, there were people in this movement in the way beginning, but also people got to witness the first trial. And people who didn't know about it now do know about it. So what's going to happen now is I think you're going to see more people outside. We have about, I would say, 100 to 200 people joining the Facebook group daily and voicing their concerns about what's happening in Norfolk County. And I think it goes bigger than just the Karen Read case. I think it just goes to the corruption in what Judge Beverly Cannoni is doing in the courtroom. And I know, Joe Krauske had mentioned the other night was you have a judge who is pro-defense. We've all watched this case. She is not pro-defense. She absolutely does not like them. But I don't think that's going to stop the supporters from showing up. I think even if the buffer zone is now 300 feet, 400 feet, they're still going to be there showing up regardless.
Now, Kevin, let me ask you from your perspective. Do you get a sense that since this first trial happened, since the coverage, the talking, the documentaries that are out, that there is more knowledge by the general public now, crossing out of the people who watch court TV, crossing over the people who are true crime aficionados, like into the general population of people? Do you see this case going there, and do you get the sense that those people are supporting Karen Read, or are you seeing something else?
I think Nick said the quiet part out loud a couple of weeks ago when he talked about how we now know that the federal investigation is over and they didn't find anything of interest, nothing exculpatory, nothing that led to charges, and but that their goal is really to make this a public relations campaign and hope that you get a couple of people on the jury that reject the evidence, and that then you make the case later on that it's too expensive to do a third trial. I think that's what we're looking at here. But I do think that the PR campaign has been very effective, and the majority of the public is only looking at the issues that the defense raises. Many of these things that have been, pretty much most of them, debunked by the evidence in the trial. But they don't see that, and they just see this kind of superficial thing that looks really mysterious and intriguing and interesting. And I just hope that they'll be willing to pay attention. I hope, well, really what matters is the jury will not come into this with preconceptions and just listen to the evidence carefully and be objective, honest, diligent jurors.
Let me ask you, Nick, because Kevin said this was like a PR campaign. From your perspective, do you see yourself as part of a PR campaign?
I've been accused of being paid, and I've been accused of being part of the defense PR team since the beginning. Nobody is part of a PR campaign. Nobody has been paid by the defense team to speak our minds and our opinions. Everybody who is out there is authentic and real. And a lot of us don't hide behind, Twitter accounts. We're all out there, and we all show our faces. We all go on camera, and we speak to local news. And everybody's there. Everyone's real. There's no paid protesters. The defense is not trying to, have this crowd outside to potentially get put on the jury pool. All 12 jurors voted not guilty for 2 counts, and they were hung on one count. So it's not us out there that's doing this. It's what's happening in the courtroom. Ultimately, that is the final decision. And now we have one of the jurors being one of her lawyers. I mean, if that doesn't speak volumes, then I don't know what else to say to the people who believe she's guilty.
By the way, one of the reasons I asked this question is we got this press release. Apparently, there's a nationwide rally for Karen Read that is planned ahead of the start of the retrial. The group that's organizing it is called Karen Read Stands Out, and they released this video. Okay, let me ask, Nick, do you know anything about this group and they're calling them standouts?
Yeah, absolutely. I mean, the people who run the standouts, they're a part of the Justice page, the Facebook page that we run. There is a website you can go to see basically every week where there are standouts. You have standouts every weekend, multiple weekends, all the time. This is a nationwide standout where I believe this is the third one. And you just have towns all over Massachusetts, all over different states, and even some in Australia, in the UK, and Ireland, who participate in these nationwide standouts. People are outraged. They don't believe Karen Read did this. And I know we've been accused of being a mindless mob, but are all these people mindless? I mean, you have people in other countries who are doing this. They're not part of a mob. I'm not part of a mob. I just truly believe that she's innocent. So we stand out and we put ourselves out there and we get criticism for it. But it is what it is because we believe in something.
Kevin, what are your thoughts about what's taking place here? I'm looking at all the towns where these standouts are taking place. There's a ton of them in Massachusetts, like Weymouth and Worcester. They're going to have one there. They're going to have it in Walpole. Then Bristol, Connecticut, Cumberland, Rhode Island. You've got Manchester, New Hampshire, Portland, Maine, Fort Walton Beach, Florida, Orlando down in Disney, San Diego, California. What's going on here, Kevin?
Well, first of all, I do want to say that I do actually believe that Nick is not part of a paid PR campaign, that he does fervently believe in Karen's innocence and has since this first became a popular story in 2023. So I'm definitely not accusing Nick of that. What I'm accusing of is the defense team and the defendant of waging a PR campaign, the purpose of which is to contaminate the jury pool. And we've never seen, I don't think, anything like it in recent history or in modern history. So, but yeah, there's no question that there's a fervent belief system that's out there. And one of the things that we'll have to study for many years after this is what about this case resonated so deeply with people. They're just looking at the surface of this. Is it their distrust of cops? Is it because you have a middle-aged white woman who has no criminal history? Do they see themselves in that? Do they just mistrust authority of the system? You know, I don't know. I think it's really something that has to be studied. You know me, I just focus on the evidence. It's nothing against Karen. And there are charges that I don't know that she had any intent to do anything wrong here in terms of that night. But the evidence is overwhelming, linking John's death to her Lexus, and not just overwhelming, but really irrefutable. And I hope the jury will see that in the trial.
All right, Nick and Kevin are going to stick around. We got a lot to get to this hour. Coming up next, will any jurors have an agenda?
The Court TV podcast will return.
What do you think happened?
I honestly do not know.
That was my one-on-one with one of the jurors from the first trial. And interesting that he doesn't know exactly what happened. I mean, he was there. He saw and heard all the evidence. And if you don't know what happened, that equals not guilty. And he clearly was a not guilty juror. And it seems like a bunch of the jurors were not guilty on counts 1 and 3, like all 12 of them. But I want you to take listen to a little bit more of my interview with him, because I thought it was fascinating, because it took us inside the jury room. It took us inside what this jury had to deal with and some of the issues and some of the miscommunication back and forth that caused what turned out to be a very messy non-verdict verdict. Take a listen.
Unfortunately, at that time, we did not fill out any of the paperwork there, nor sign it. So we were under the understanding that each charge could not be treated separately. And so we continued to deliberate, despite the fact that we had agreed on 2 of the counts as not guilty.
Did any of this evidence convince you one way or the other about whether or not John O'Keefe was struck by a car, that the injuries were consistent with being struck by a car?
This is where we debated for hours. For some of us, it was conclusive evidence that she was guilty. For some of us, though, the injuries were not consistent with a pedestrian struck per se. It seemed inconsistent. So for some of us, it solidified that essentially it was not a collision with the motor vehicle that ultimately caused the blunt force trauma to his head.
And that's not the only juror that we heard from. WBZ interviewed a juror March 6, 2025, earlier this month. And it was actually an alternate juror from the first trial. Victoria George, who was an attorney herself and was an alternate juror in Reed's first trial, sent the following to WBZ TV. I was a fair-minded juror who left this trial questioning the integrity of the system long before the defense filed a motion to dismiss with allegations of jury tampering. It is the Reed case itself and the fact that it is still being brought that has left many in Massachusetts wary, distrustful, and scared of our system. As a lawyer, this really saddens me even more because I remember how much faith I had in our system as an optimistic law student. That juror, who's a lawyer, is now a member of Karen Reed's defense team. So it seems like at this point she's really been convinced one way about what happened to John O'Keefe, that it had nothing to do with Karen Reed. But I'm wondering, with all the notoriety here and the passionate feelings that people have about this case after the first trial, let's talk about the jurors in the second trial, and that brings me to my next question. Will any jurors have an agenda? Will they be jurors who want to get on that want to be part of the trial because they have an agenda? Here with us, Massachusetts trial attorney, served as special counsel to Johnny Depp in his defamation case, Wayne Dennison, and Massachusetts criminal defense attorney, college instructor, and author, Peter Ellikin. All right, Wayne, do you think there's going to be any jurors that show up with an agenda?
I suspect that there are going to be potential jurors that show up with an agenda. This is a obviously well-publicized case. But
it's not just the publicity. It's not just the publicity, Wayne. It's that people are dug in. Like, the only thing I can compare this to is politics, left versus right. That's the way it plays. Go to that courthouse. Wear pink one day, I'm wearing blue tonight. Wear blue another day, and see how you are looked at by the other side. That's what's happening. So I'm wondering if someone, one of the blues or one of the pinks, with those passionate feelings, is going to bring that into the jury pool and try to get on that jury.
So you get a very limited amount of information from the jury questionnaires. You get where the person lives generally, you get some spousal information, you get some educational information, you get some information about how they're employed and about their interaction with the police. But there's a very limited amount of information in this courtroom that you get relative to the jury pool. You're entitled to do lawyer-conducted voir dire, but if somebody is on this jury or a potential juror who is absolutely dug in, there's going to be very little that you can do if that person is not honest and direct to keep them off the jury.
Peter, this is one of those cases where I could see a stealth juror attempting to, or perhaps getting onto this jury, because so many, I spent some time up there, people have opinions, and people have more opinions now as we go into the second trial.
Yeah, in my 40-something years of being a member of the bar, I've never, ever seen, such public passions about this. And one of the problems with this case, of course, is that you're not going to find any juror who never heard about this case. I'd almost be skeptical if somebody was so isolated that they'd never heard it. We already went through the whole first trial also. So with everybody knowing about it, is there any absolute foolproof, fail-safe system to keep a juror with an agenda out of it. Somebody who either wants to write a book or just feels so passionate.
I don't even think it's a book. I don't think it's like the O.J. juror book deal, right? I think this is people either want to see Karen Read set free, or you talk to the other folks, they want to see her fry. Like, to me, it's not about the classic, I want to be on a jury on a high-profile case because I'm going to be famous myself. I think it's people who want to see justice, however they perceive this case, happen in there. And that's why it's different, Peter. I think it's different than the classic, we're going to write a book, I'm going to be famous deal.
That is true. I would agree with you on that the passions are so embedded, so extremely deep here, that people really are so invested in this case that they would like to be, a deciding member, as opposed to somebody outside with a picket sign or somebody giving their opinions, over the water cooler to their friends. They'd like to be the decider. So there's ways to kind of weed that out if you really have a good jury selection system. But like I said, there's no fail-safe, foolproof method to prevent that. I'm thinking in all likelihood it won't happen, but could it happen? Absolutely.
All right. Our lawyers are staying with us. Coming up, what is the biggest problem prosecutors have in the retrial?
Now, back to the Court TV podcast.
I'm Vinnie Politan. We continue our investigation of the death of Boston police officer John O'Keefe, a man who served his community and took care of his family before he was killed by someone he knew and trusted. The question is, who actually did it? Here's the story. Karen Read was a college professor living a relatively normal life in Massachusetts. Then one snowy night in a town called Canton, her boyfriend John O'Keefe, a Boston police officer, ended up dead on the front lawn of another Boston police officer. Karen Read was charged with his murder. Prosecutors say she purposely ran him over with her SUV. But Karen Read has literally proclaimed her innocence on the courthouse steps and has thousands and thousands of supporters in Massachusetts and around the country who believe she is innocent. The jury deadlocked in the first trial, and now both sides have been slugging it out inside the courtroom while supporters are voicing their opinions outside the courthouse as the nation waits for the upcoming retrial of the century. This is going to be a battle. I think this is going to be more intense than the first one. And I think just what we've seen in the buildup, the buildup to the first one was intense as well, but it's just another notch up there. So the defense obviously believes Karen Read 100% innocent, was framed, etc. But they also believe there are a lot of problems and a lot of things the state did, the Commonwealth did, that were problematic, and they filed a motion to dismiss. It was denied, but take a listen to some of the arguments from Alan Jackson.
There is no other conclusion but that Michael Proctor and other investigators intentionally secured these videos. They withheld the evidence from us, and they withheld the evidence from the prosecution team. This was a pattern engaged in by the Massachusetts State Police, by the Canton Police Department, over and over and over again. And now we know through this new revelation that it was intentional. The prejudice the defense has suffered is legally presumed, and it's also factually proven. And thus the only remedy is dismissal.
And one of the amazing things in this case is that both sides have been on top of everything that the other side is doing or hasn't done, information that they provided or didn't provide, and all the issues that some of the witnesses have with things that they've done or haven't done in the past. So prosecutors have the burden, though, and that brings us to the next question in our investigation, which is, what is the biggest problem prosecutors have in the retrial? What's the biggest problem they have? Joining me, Karen Reed supporter, creator of the Justice for Officer John O'Keefe and Karen Reed Facebook page, Nick Rocco, and the author of the book Storm of Suspicion, the Karen Reed trial, Kevin Lenahan, with us. All right, let me start here, and then let me put this up on the screen because I think this is one of the big issues in the case, obviously. The lead investigator, Trooper Proctor. The state police trial board fired Massachusetts State Police investigator, Trooper Michael Proctor. It dishonorably discharged him, and obviously it was for things that happened during the course of this case, including some text messages. Take a listen.
So these came from me. From all accounts, he didn't do anything wrong. She's a whack job. Yes, she's a babe. Weird Fall River accent, though. No ass. These came from me. Funny, I'm going through his client's phone. No nude so far. I hate that man. I truly hate him.
You weren't so much as objectively investigating her as objectifying her in those moments, correct?
Again, Mr. Jackson, it was a poor choice of words and a joke.
All right. Nick, how big of a problem is Trooper Proctor for the Commonwealth here?
Well, he was found guilty of 4 different charges by the trial board. And one of them, you know, the text messages was bad. Him driving his cruiser while he was working, drinking, that's bad. But I think the biggest one is the fact that he was found guilty of being biased in this case. And I think once the jury hears that he was biased in this case, anything that he touched or had to do with, I think the jury is not going to believe to be true and accurate, which I think anybody who sees this case believes the same thing. It's that him being fired is going to have a huge impact at the way the jury sees this case going forward. And now the defense is saying it's a cover-up, and you have the lead investigator being fired for his conduct in this case, whether it's text messages, you know, leaking information to non-law enforcement, or the other one just being biased, which is now a known fact. That's not going to be good.
Kevin Lenahan, this is, I mean, we cover trials here on Court TV. That's all we do. I've never seen anything quite like this, where the lead investigator is now gone. The lead investigator is biased. This is problematic. This is like, we're not quite there, but we're close to like Mark Furman country here.
So there are 2 things that I'd like people to remember about this. One is that there is no evidence at all. Nothing was uncovered that showed Michael Proctor planting evidence, manufacturing evidence, or in any way fudging the investigation. But if you want to Mark Furman this guy and reject any evidence that he was connected to, fine, go ahead. The fundamental evidence that shows Karen's Lexus struck John O'Keefe has nothing to do with Michael Proctor. The main evidence, the taillight pieces that were found in a debris pattern near where John's body was found, those were not collected by Michael Proctor. Those main pieces that were found that night were found by the CERT team. Michael Proctor never went to the crime scene that day. The fundamental evidence is the vehicle data that shows Karen going in reverse at 24 miles an hour for 60 or 70 feet. And the way that correlates with the location data and the Waze data on John's phone. And also that's a bulletproof correlation that shows exactly what time John was struck by the Lexus. In addition, the GPS on John's phone shows that he never went inside the house. So if you want to get rid of all the Proctor evidence, go ahead. It doesn't really impact the fundamental evidence of this case.
Now, I want you to take a listen to the cross-examination of Caitlin Albert.
You drove past the front lawn, correct?
Yes.
You drove past the flagpole, correct?
Yes.
And in all that time from when Tristan Morris pulled out of the driveway and drove right by your parents' front lawn, you never saw anything of the things that I previously asked you about, correct?
I did not, but I also was not looking.
You saw no baseball hat, no sneaker, no pieces of red plastic, and no 6'2" man, correct?
Correct.
And you also didn't see any tire tracks in the snow, did you?
Not that I can remember.
All right, Kevin, why didn't anyone see John O'Keefe there? One witness, I think, saw what she described as a blob, but no one saw John O'Keefe on the front lawn that was leaving that party?
Well, Nick, maybe we should try an experiment tonight. You where you are and me where I am. We'll go out and lie in an area on the lawn and just not move and see if any cars driving by notice us. I'm guaranteed that none of them do. And interestingly here, Lucky Loughran testified that he last plowed the street at 5:30 a.m. Now, even under the conspiracy theory put out by the defense, John must have been out there by 5:30, right? And Lucky went up and down a couple of times, so he probably made a pass at 5:45 too. This is just minutes before John was found by Kerry and Jen. So Lucky didn't see him that time either, despite going through this well-lit vehicle. It's just not natural to see a dark, unmoving object lying in somebody's yard. Your eye doesn't pick it up. It's in your peripheral vision. And unless something is moving, it's not going to draw it to the attention of your conscious mind.
Interesting. I think it's a problem, but we shall see. All right. Nick, Rocco, Kevin Lenahan, appreciate it. Great to see you. Thanks so much. Still to come. What is the biggest problem Karen Read has in the retrial?
She said, I hit him, I hit him, I hit him.
This is the Court TV podcast.
As I was ventilating, I was able to ask, did anybody see anything? What happened? And there was one individual that replied several times, I hit him, I hit him.
She just repeated the phrase over and over again, I hit him, I hit him.
So she said, I hit him. She repeated it. There was a woman standing across from her who I believe at that point said, you're hysterical, you need to calm down, you're hysterical. She repeated, I hit him.
That's an alleged confession by Karen Read during her case. The juror that I interviewed didn't necessarily buy it, but Karen Read was asked point blank about whether she hit John O'Keefe in the Investigation Discovery docuseries, A Body in the Snow, The Trial of Karen Read. Take a listen to her answer.
So, did you drive your car into John?
I did not drive my car into John. Didn't reverse it. Did not hit John with my car.
Is there any chance this was an accident?
There is zero chance this was an accident. There was zero chance John was hit by a vehicle.
You're tired of it? You've spent so much...
No, I just...
I have to
no, I'm not tired of it. I hate answering it because I feel like I'm being so scrutinized. Like, did she blink 3 times or twice? And did she, like, smirk or look to the right or down and up and left and whatever? And, like, it just feels so fake, even though it's true. I rather, like, explain everything else. And, like, I did not hit John with my car. Like, I can't make it sincere enough.
Interesting response, right? I mean, a lot of people reacting to that response in different ways. But as she gets ready for the retrial, I don't know if she's going to testify. I don't think she will. You know, she has the opportunity, but I don't think she will. But that brings us to the next question in our investigation. We did one side, now we're doing the other side. What is the biggest problem for Karen Read that she has in the retrial? In her defense, here with us, trial attorney, served as special counsel to Johnny Depp in his defamation case, Wayne Dennison, and Massachusetts criminal defense attorney, college instructor, author Peter Ellikin. I want to take a listen to Jennifer McCabe and her testimony on cross-examination from that first trial.
I'm not sure if it's in this document, but I can tell you today with 100% clarity, she said, I hit him, I hit him, I hit him on that morning.
All right, let me ask you, Peter, is this alleged confession the biggest problem that Karen Read has?
It is a problem, but here's where it gets complicated. There's really no smoking gun. They haven't nailed it on here. There's a bunch of reasonable doubt because certainly a confession would be very, very strong, and yet the defense has answers to that. They say that Jen McCabe never mentioned I hit him, I hit him, I hit him until didn't mention it. The grand jury didn't mention it at the time. Here you hear a confession. You don't tell anybody. Months later, when the people in the house are in trouble, are being accused of things, at that point you bring it up. So you see, so what I'm saying is, yes, that's strong evidence, but then each and every one of these times that they bring up evidence, they don't quite nail it because there's just so much reasonable doubt, and the defense has a very logical explanation for each and everything. The shattered taillight, that is a very strong bit of evidence all over the lawn. Wouldn't that be proof that she backed her car and it hit him? And yet then the defense says, yeah, but there were 2 searches of the lawn earlier in the day, and we used a leaf blower, and nobody found anything. And then later in the afternoon, you tell us you can see it from the road. There's so many pieces all over the place, and we could have nailed it at the. We say it wasn't even damaged when it got to the police garage, and yet we have this video that cuts out, and every time it gets near the taillight, suddenly it gets fuzzy and it cuts out again, and there's a bunch of strong evidence the prosecution has, but there's kind of an answer for every one of them. And that's why the jury, I think, is going to be like this juror you interviewed, where they're going to say, I don't know, I wasn't there. And we were hearing 2 opposing sides, 2 good arguments. And of course, as the trials go, tie goes to the runner. Any confusion, reasonable doubt, that would favor the defense there.
Let's take a listen to the new prosecutor, Hank Brennan, talking about some new evidence.
The issue regarding glass, I expect, is going to be a issue in the next case, and I say that because we learned last night, for the first time on a public airing of an episode, that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that. And also, there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face. Never heard that before. So we have this evolving or new testimony, or statement rather, statements about glass. And so I think first, I'd like to consider this new information that we just learned last night.
All right, Wayne, how big of a problem is this? New evidence coming from Karen Reed's interview on that docuseries saying that, hey, he grabbed my vodka soda glass, and then I pulled a piece of glass from his face the following morning when she found him.
It's a significant problem for a couple reasons. First of all, I don't think Karen Reed is going to testify in this trial. However, they can put Karen Reed on the stand by playing her interviews and playing the portions of her interviews that support the prosecution's theory of the case. The biggest problem for Karen Reed is, quite frankly, the first trial was a dress rehearsal. They did not prepare in the previous trial their witnesses in an appropriate way. You're going to get a whole different level of witness prep. The prosecution is going to throw Michael Proctor under the bus long before Karen Reed and their team even get a chance to do so. And they're going to distance themselves from Proctor because they're going to say, hey, you can discount him entirely, and we have evidence from the speed at which the car backed up. I mean, she indicates on television that she didn't reverse the car. Of course she reversed the car. How do you get out of the driveway? Karen Reed is going to be testifying in this trial irrespective of whether Karen Reed chooses to take the stand.
Let's take a listen now to more cross-examination of Jen McCabe.
You were asked on that morning, January 29th, 2022, as you drove to the location and ultimately to 34 Fairview, what ultimately happened. And your testimony was, as you approached, my client was searching frantically for John O'Keefe.
I don't believe I said she was searching frantically for John O'Keefe.
Searching frantically?
She was screaming frantically in the back seat and texting in the back seat.
Was she just sitting there, curled up in the back seat, sucking her thumb, or was she searching out the window?
She was screaming between Kerry and I. So I'm not really sure how she saw John over here when her head is up here screaming and then looking down and texting.
Was the whole point of that trip, Miss McCabe, to search for John?
It was, because she knew where he was.
The whole point of that trip was to look for him, correct?
She directed us to go to 34 Fairview.
The whole point of the trip was to look for John, correct?
At 34 Fairview, where Karen said to go.
All right, Peter Elkin, how much of a problem is this for Karen Reed, that she is the one who finds John O'Keefe in the midst of this snowstorm when she's in the car with two other people? Neither one of them say they saw John O'Keefe. She's in the back seat, leaning between them, according to the witnesses, and she's able to spot John O'Keefe when no one leaving the party saw him, when no one in the car saw him other than Karen Reed.
Well, I think it's no problem whatsoever at all. They went to look for him. She was not the driver. She was specifically looking for him. So when you say other people leaving the party didn't see him, they weren't looking. They just got in their car and drove off. And she's there. The whole point is to go scan the ground there and see if we can see him. And if you see the pictures of that house, it's not a huge estate. It's a very small suburban lawn there. If you're looking for somebody, I think you'd spot them in a heartbeat. And Karen Reed is a sharp, educated woman, and if she's there to look for him and looks out the window, she would see him, which is different than the other people who are leaving the party and they've been drinking and they're not looking for anybody and they're driving, or people driving down the street may not be looking, but she was specifically looking. So I don't think that's a problem at all.
All right, I only have 15 seconds for each of you. Who has the advantage going into the retrial? Wayne, first.
I think the prosecution has the advantage. They know exactly what the defense is intending to do.
Peter, who has the advantage?
The defense also knows what the prosecution is going to do because they had a dress rehearsal. I think the only reason the defense has a slightly better thing here is because of reasonable doubt. I don't know that either side is going to conclusively prove things either
So what
way.
you both are telling me is that you guys are deadlocked as well. There we go. And it continues. Peter Elkin, Wayne Dennison, thank you so much. You know, traditionally in a retrial, it is advantage prosecution. In all the cases through all the years here at Court TV that I've seen, they can make adjustments and figure out where the doubt was for some of the jurors. But Karen Reed's trial may be different because the defense is the one who will get the insight from the jury, because a juror from the first trial is now on the defense team. And that is advantage defense second time around. I'm Vinnie Politan. We'll keep covering it, and we'll keep digging for answers as the investigation continues. There you have it. If you want to see more in-depth reporting on the latest true crime stories, you can see me every weeknight, 8 p.m. Eastern on Closing Arguments. Thank you so much for downloading. And as always, please don't forget to hug the kids.
This podcast is a production of Court TV. Go to CourtTV.com for more content, trials on demand, and to find out how to watch Court TV in your area.